You already know that statutes are one of the four primary sources of law. A statute is a written law enacted by a legislative body such as Congress, the state legislature, or city council, and then signed by an executive, such as a president, governor, or mayor. At both the state and federal levels, statutes are published in three different formats: slip laws, session laws, and finally, statutory codes. A slip law is the first publication of a newly enacted statute. Once a bill has been passed, it officially becomes law, is assigned a public law number, and is published as a slip law. For example, the Patient Protection and Affordable Care Act, commonly called the Affordable Care Act or Obamacare, is a United States federal statute signed into law by President Barack Obama on March 23, 2010. On that date, it would have been immediately available in slip law form as Public Law 111-148. Each slip law contains only a single piece of legislation, though that legislation may affect multiple laws. This is especially true for federal legislation, where omnibus bills are commonplace. Some states, such as Illinois, have a single subject requirement. This means all bills are confined to a single topic. You may cite to a slip law when a law is so new that it hasn't been published yet in any other form. You'll rarely use slip laws in your legal research, but you should understand their role in statutory publication. All the slip laws from a particular session of the legislature are compiled chronologically into session laws. Public law numbers identify the session of Congress that passed the law. For example, the healthcare law was assigned Public Law Number 111-148. This means it was the 148th law passed by the 111th Congress. Session laws contain all the laws passed, even those that have been later amended or repealed. Think of session laws as a chronological capsule of a moment in time that records all the final versions of laws enacted during a single legislative session. Session laws can be found in official and unofficial sources. Official sources are those published by the government. The federal publication of session laws is called the statutes at large. If a law has been incorporated into a session law collection, but not yet into a code, you should use the session law source for your citation. Going back to our example, if you wanted to cite to the session law for the ACA, you would look to the volume of the statutes at large covering the 111th Congress. Each state has its own source for session laws. For example, in Illinois, session laws are compiled in the Laws of Illinois. In fact, the term session law is somewhat generic, and actual titles and terms can vary from jurisdiction to jurisdiction. It's important to know the source of session laws for any jurisdiction you research. Table 1 in the Blue Book Manual can be a good reference for learning the names of jurisdictional resources. Table 1 will also help you learn about the citation and numbering format for the session laws of your jurisdiction. Session laws are also published online. You can find them on Lexis, Westlaw, and Bloomberg. On each of the commercial databases, the coverage may vary. For example, Westlaw has the statutes at large from 1789 to 1972, while Lexis carries the statutes at large from 1776 to the present. The Library of Congress also provides free access to laws from recent sessions of Congress through congress.gov. Many states also make session laws available via state legislative websites. Session laws can be very helpful when looking for historical versions of a particular law, or when you need to look back on the full language of the original legislation. This can be especially helpful when thinking about large, complex laws that might cover more than one code citation. Additionally, current session laws are authoritative forms of the final version of a law, but because session laws are published chronologically and contain current, amended, and repealed versions of the law, it can be difficult to find all the relevant current language and law on a single topic by using session laws. That's where the third and final statutory publication comes in, the statutory code. A code is a subject-based arrangement of laws. The statutory code contains only those laws in effect at the time of its publication and is updated to reflect changes mandated by new statutes. When working with statutory law, you will primarily use codes. Codes are the easiest form of statutory law collections to work with because of their topical organization. It's unlikely your research task would be to find the legislation from March 23, 2010. Rather, you'd be asked to do something like find all the relevant legislation on the insurance mandate. The official source of the federal code is the United States Code. The United States Code Annotated, or USCA for short, and the United States Code Service, or USCS, are both unofficial sources of the code. These versions contain the same text when it comes to the law, but include editorial enhancements or annotations. The USCA is available on Westlaw, and the USCS is available on Lexis Advance. The code is also available on Bloomberg Law, but Bloomberg Law has an unofficial, unannotated version of the text. The only official online version of the code is freely available on the Federal Digital System, or FDSYS, which is the website for the Government Publishing Office, or GPO. If a law has been codified, you would always cite to the official code. The ACA is a complex law that touches many subjects. Parts of it are codified in over 20 different sections of the U.S. Code, with the bulk of the provisions found at 42 U.S.C. Section 1300. Each state has its own statutory code as well. The titles can vary greatly from state to state. For example, in Indiana, the statutory code is simply the Indiana Code. In Illinois, the official code is the Illinois Compiled Statutes. Remember that Table 1 in the Blue Book can help you identify the proper name of a code for a specific jurisdiction. Understanding the process of statutory publication is important in legal research because a good researcher should be able to find the necessary law, regardless of whether it's a very recently enacted law, a law enacted semi-recently but not yet codified, or a law that has been incorporated into the formal published statutory code. Being able to follow the progression of statutory publication will also allow you to ensure you're citing to the most appropriate version of the law. In the next lesson, you'll learn more about the legislative process and all the supportive documents that relate to the creation of codified law. Before moving on, take our quiz to make sure you understand the process for publishing statutory codes.